Okay, here we are in Unit 6, a summary of violations of license law, penalties and procedures. We do need to know some legal terms when we go through this. Breach of trust is basically breaking of a promise. Commingle is when you are mixing somebody else's money trusted to your safekeeping with your own money, not allowed. Concealment is when you're withholding information that should be passed on to the customer or client. And conversion is the licensee's use or misuse of the client or customer's monies. Culpable negligence, bit of a catch-all there, failing to use care and attention to your duties as a real estate agent. Failure to account and deliver, or account for and deliver. This is failure to pay money to the person who is entitled to it. Fraud is intentional deceit, when you deliberately say something incorrect or misrepresent something and the person acts upon it and is harmed by it. Material fact, neglecting to say something which is material fact is relevant to the transaction, relevant to the property. And misrepresentation, you are saying something which is untrue. And moral turpitude, another catch-all, conduct contrary to honest or good morals, and crimes including embezzlement, larceny and robbery. So there is a complaint process that the public or anybody actually can use with regards to complaining about a licensee. You have to file a complaint first, then there is an investigation of the complaint by DPPR, and then they will hand it over to what's called a probable cause panel to make sure that the complaint is valid. So that's just a little other hoop and hurdle they've got to step through. And then after that, you will go to back to DPPR and FREC, and a formal complaint is issued. Then you have a choice of an informal or formal hearing. A final order will be issued, and then you have a chance to appeal. Let's go through those one by one. First of all, filing a complaint. Complaint is an alleged violation of law or rule, and it is filed on a uniform complaint form provided by DPPR on their website. Has to be in writing, and it can be determined legally sufficient if a violation of the Florida statutes 475, 455 or any of the other relevant ones have been violated, or a DPPR rule or a FREC rule. The complaints may be anonymous. They will investigate anonymous complaints or one made by a confidential informant, provided that the complaint is in writing, legally sufficient, and the alleged violation is substantial, and the DPPR has reason to believe that the alleged violations are true. Here's a form which you can download off DPPR website, and this is where you would enter your complaint. The complainant, here's the person who files the complaint, and a copy of the complaint is subject to the licensee who is subject of the investigation. And licensees have a chance to submit a written response. DPPR will conduct an investigation. They may send out investigators to look at your books or so forth. DPPR issues an investigative report, and then they'll decide to send that to a probable cause panel. And the complaint and information obtained during the investigation is confidential until 10 days after the probable cause is found. If DPPR or FREC decide that the possible complaint is so serious that they really don't want the licensee to carry on doing whatever he's supposedly be doing, then they will issue an emergency or summary suspension. If investigation reveals public is in danger, then the DPPR or FREC may decide not to allow licensees to continue to work during the disciplinary process. This is a quick graph of what's going on here. A complaint turns into a legally sufficient complaint. They can issue an emergency suspension order. Then it's given over to the probable cause panel. This is two members of FREC, either one current and one ex, or one current and two FREC members, current FREC members, or one current and one ex. One of them, though, has got to be a broker. And it's up to them to determine whether probable cause does exist and the case goes forward. They may decide that it was so minor that they may dismiss the case or dismiss with a letter of guidance. It goes back to DPPR and FREC, and they will finally issue a formal complaint if probable cause does exist. Sent by email, regular email, and certified mail to the address of record. That's why it's important to keep your mailing address up to date and check it regularly. And also a copy is sent to the sales associate's broker. And you've got 21 days to respond to this. Included in the complaint is an election of rights form. Down at the bottom here we can see you can choose to have an informal hearing in front of FREC if you don't dispute the facts, a formal hearing in front of an administrative law judge if you do dispute the facts, or ignore the complaint and FREC will go ahead and hold a hearing in your absence. You may want to get your attorney and the department's attorney to get together before any hearing and discuss a settlement. This is called a settlement stipulation. It's an agreement of the facts of the case and the penalty reached. Stipulation, though, must be approved by FREC at one of their hearings. You may choose, under certain circumstances, to voluntarily relinquish your license for permanent revocation. That means you're out of the business forever. This may help you avoid the disciplinary hearing and any results from it. Do not confuse this with just voluntary relinquishment only, when you just decide to maybe relinquish your license with no disciplinary action taking place. After that, you can actually get your license back. The case is presented in a hearing. If you go for an informal hearing at one of FREC's legal agenda sessions up in Orlando, you mustn't dispute the facts. You have to give at least 14 days notice. You have to be given 14 days notice of the hearing. And you present the case to FREC at a commission meeting. And you can bring evidence or witnesses to support your case. And at the end of that, they will issue you with a final order. If during this hearing you dispute the facts, then the hearing is stopped and then a formal hearing will be scheduled. If you actually fail to respond to the election of rights, then you have waived your rights of a hearing and the case will proceed and be heard by FREC. If you choose a formal hearing, then you will probably go in front of an administrative law judge. Once again, you can bring evidence or witnesses to support your case. The hearings are conducted under Florida Statute 120, which is the procedures statute. And the judges are selected by the Division of Administrative Hearings. They may issue subpoenas, summon witnesses, and they will, at the end of the case, give a recommended order to FREC of the findings, conclusions, and recommended penalty. Recommended order submitted by administrative law judge will include the findings of fact, conclusions of law, and the recommended penalty. And then FREC will look at this. They may decide to accept it, they may want to reduce it or increase it, and they will issue a final order. Final decision as to innocence of guilt and penalty. The probable cause panel members aren't on the final hearing, and the FREC will consider the law judge's report and recommended order and file exceptions, and a copy is mailed to all the parties, both the complainant and the licensee, and the order becomes effective after 30 days unless you've already been summarily suspended. You've got 30 days to appeal. You have to file it with the DPPR and the district court. The court will stop the stay of enforcement, request a stay of enforcement. They will stop the execution of the final order until the appeal is heard. We've got different types of penalties that occur to a licensee. Administrative penalties, which can be administered by FREC. We've got civil penalties and criminal penalties, both of which must come out of a court of law. The administrative penalties, the very minor ones, or the minimum, is they can deny your application or refuse to renew your license. They can issue with a letter of non-compliance, of which you've got 15 days to comply. They may issue a citation on the spot for 100 to 500. They may place you on probation whilst completing the terms of a penalty. And you may also be fined up to $5,000 on administrative fine. They may suspend your license for up to 10 years, or they may revoke your license. They cannot lock you up, and they cannot make you pay restitution to an injured party. That's up to a court of law. A notice of non-compliance is usually issued for a minor violation. You've got 15 days to correct it, and if you don't, then you'll end up with a formal complaint. A citation, once again, is 100 to 500 plus extra education may be required. You've got 30 days to object to this and file a complaint. Administrative fine can be $5,000 per violation. They can suspend your license up to 10 years. Whilst you're suspended, you must continue your education to keep your license going. Sometimes DPPR will issue a license through the error of FREC or DPPR. Maybe you didn't fill out the form correctly and they missed it, or maybe they didn't receive payment from you. Therefore, they will revoke your license, but you will get your license back as soon as you completed what missing requirements you had. Once again, they can put you on probation, they can fine you, they can ask you to do educational courses, and they can put you on probation. Any civil and criminal penalties are issued by a court of law, and if REC recognizes any criminal violations, they have to report it to the state's attorney office. The worst that we talk about in the book is a third-degree felony, which can be falsifying an application or getting a license by fraud or cheating, unlicensed practice of real estate, or theft of a license exam, a state exam, and that can be up to $5,000 per count, and it will be referred to the state's attorney office. First degree misdemeanor penalty, once again, it'll be from a court of law, failing to provide accurate and current rental information for a fee, and the penalty is a fine of up to $1,000 and or 1 year in jail. And the second one is the secondary misdemeanors are a criminal maximum of 500 or 60 days imprisonment, and the one we use for that obviously is false advertising. You have a duty to report to FREC within 30 days if you have ever been convicted for a crime anywhere, including misdemeanors, felonies, placed on probation, or pleaded no contest. Here is a criminal self-reporting document which you must use. When you are taken to court and a judgment issued against you, then you are required to obey the orders of the court. If the person that needed to be awarded the damages cannot get the money out of you because an assets search shows you don't have the sufficient funds, the offended party can make a claim against the Real Estate Recovery Fund. For them to be able to do that, the licensee who committed the crime has to have had a current valid active license at the time the act was committed. The act has got to be against the licensee, not against a brokerage. And the licensee was not the owner or the buyer or the tenant of the property, or not an officer in a business that was the owner, buyer or tenant, and acted purely or solely as a licensee in the transaction. You have to have had a civil lawsuit in a Florida court against you. The suit cannot be against the brokerage firm. You have to be awarded a judgment, and the court has diligently attempted to collect the judgment on you through a writ of execution, unable to locate enough assets of licensee to satisfy the judgment. There's no appeal going on at the time, and the claimant cannot be your wife or husband. The claim must be made within 2 years of the alleged violation, or 2 years from the discovery, but no more than 4 years from the alleged violation. The amount that could be paid from the fund would be $50,000 per transaction, or an aggregate of $150,000 against one licensee. The fund is funded by license fees and fines. Every time you put an application or renew, then you'll pay $1.50 per year for sales associate, $3.50 per year for brokers. When the fund gets below $500,000, then these donations from you are required, and then the fee collection is dropped when fund reaches $1 million. Reimbursements from the claimant for compensatory damages only. Actual monetary damages occurred. The fund will not reimburse to the offended party attorney's fees or court costs or punitive damages or interest damages. You will have to pay those yourself. And when a payment is made out of the recovery fund on your behalf, then your license will be suspended until you pay it back to DPPR with interest. If you comply with an escrow disbursement order and you're still sued and the judgment is against you, then FREC will authorize a broker to reimburse the broker for any amount of the judgment against the broker up to $50,000. No disciplinary action. License suspension will be taken against the broker. The broker must notify FREC of the court case and diligently defend it in court. FREC is authorized to reimburse also the broker's attorney fees and court costs from the other side, but that is only for EDO claims. And that is the end of chapter 6, and it's a little bit of the quick run through there, but that's it until the next chapter. Thanks very much.